Hello, everyone. Good afternoon. So nice to see you all. My name is Allison Elsner, and I'm the CEO at the San Bernardino County Medical Society. And we are very excited to be presenting this Learn at Lunch webinar today, The Business of Medicine, Buying, Selling, and Merging Practices with Confidence. And we are presenting this in partnership with our sister organization, the Riverside County Medical Association. And we are both very, very thrilled to bring you something that is going to really help you in your practice settings. We would like to just remind you that if you can keep yourself on mute, that would be wonderful. And we will have an opportunity for questions after the presentations, and you can enter those in the chat feature, or you can ask those verbally if you'd like, and we'll open it up after the presenters finish their remarks. So right now I'm going to go ahead and introduce them to you. First of all, Pamela Thakur, JD, LLM, is the managing attorney of Thakur Law Firm, APC. And we do want to also let you know that Thakur Law Firm is a trusted business partner for both San Bernardino County Medical Society and Riverside County Medical Association. They are the preferred legal partner for both organizations and have helped many physicians over our time working together. Thakur Law Firm is a full-service firm in several different aspects of healthcare, business, and employment law. With 20 years of legal experience, Pamela represents clients on a full range of estate, trust, healthcare, and employment and business matters. She regularly provides advice and counseling to assist with compliance and measures to avoid litigation for physicians and their practices. She also has substantial experience in estate and business planning and has assisted hundreds of clients administering both. Pamela also works with clients to handle all areas of estate planning, trust administration, and contested matters involving wills and trusts. She regularly provides advice and counseling to assist with compliance and measures to avoid litigations for physicians and their practices. And we welcome you, Pamela. We are also very excited to welcome Jack Ryan Quirk. Jack Ryan Quirk began working as an associate attorney at Thakur Law Firm, APC, in May 2025, after working as a law clerk at the firm since November 2024. Jack Ryan works on both litigation and transactional matters. His civil litigation experience includes partnerships and contract disputes. On the transactional side, he advises on medical corporation formations and agreements, corporate governance, and regulatory compliance for in-house clients across labor and employment law, data privacy, and healthcare. Jack Ryan received his Juris Doctor at UC College of the Law, San Francisco, formerly UC Hastings, where he served as co-executive notes editor for the UC Law Business Journal. Prior to joining the firm, Jack Ryan was a law clerk for a real estate litigation firm and an in-house legal intern for a biotechnology company. So Pamela and Jack Ryan, we're going to turn it over to you. Welcome and thank you.
Thank you for the introduction.
Thank you. Let me go ahead and share my screen. Hold on. Sorry guys, just bear with me. I need to share my screen, which I did earlier, and let me see how to do that here. Give me one moment. There we go. All right, everyone. So thank you for joining us in this Lunch and Learn. Very honored for being able to be part of this relationship with both Riverside County Medical Association and San Bernardino Medical Society. I've had the privilege of working with them for a number of years and representing a number of the physicians and their practices. Let me just confirm this can be seen. Give me 1 second. Just for technical issues, let's just make sure it's easily viewable. There we go. So in terms of my background, I have been doing this for about 20 years and representing physicians in pre-litigation, litigation, from inception of the decision whether or not to start moving forward with the process, to sell a medical practice, to purchase a medical practice, what is required in terms of a selling practices, due diligence requirements, how to avoid litigation in terms of the production of relevant documents, the regulatory requirements, the key documentation that's required, and avoiding any anti-Stark violations if the medical practices are accepting any federal healthcare types of insurances. So just a disclaimer, we're not giving any legal advice. This is just to help you in terms of planning, deciding whether or not to sell your practice, what to look at, some of the key issues, the types of agreements, the letter of intent, handling of patient records, the transition process, consulting employment, non-competes, and then transitioning the medical practice. So the first thing I always ask my physician clients is whether or not they have any types of Medicare or Medicaid clients, and if they're accepting that. Because if they're thinking about selling their medical practice, I always recommend that they get evaluation done. The reason being is that due to the anti-kickback statutes, if the purchase price is not for fair market value, there could be an allegation that the medical practice sale violated the anti-kickback statute. So in order to avoid that, if you have any Medicare and Medicaid patients that you're accepting, there's billing through Medicare or Medicaid, then I always recommend getting an evaluation done. And it should be based on different objective factors. And if anyone needs a referral, not only do the associations have some, we recommend them, but this should be someone who has experience with valuing what the fair market value would be for a medical practice. And so some of these appraisals, what they look at, it's a combination. So it's not just the finances. They look at 3 different approaches. So there's the asset-based valuation, there's the income-based valuation, and the market-based valuation. So the asset-based valuation looks at what is the value of the assets that are being sold, generally along with goodwill of the practice. And a lot of times what they're really looking at is what are the financials looking like for the last 3 years, in addition to other intangible assets. There's also something called a market-based valuation that gets factored in, which is looking at other similarly situated medical practices. So in order to avoid any anti-Stark issues, any physician who's looking to sell his or her medical practice, or if you're in a group, should always get evaluation done before the negotiation process begins, so that practice can be marketed and sold for fair market value. And part of this process, preparing for the sale, is not just getting the valuation done, but you want to work with the right team of people. So that includes healthcare attorneys, accountants, financial planners, potentially business brokers that specialize in medical practice sales. I received a purchase agreement from a physician who was working with a general broker, and all of the forms through the commercial real estate association brokers are completely incorrect and not applicable for the sale of a medical practice. And so there are a number of different violations that basically would transpire had the seller gone forward with working with a general business broker. So even the type of language, the terminology, the issues, all of that needs to be very specific to selling a medical practice. And it's important that your CPA also understands what types of benefits you have for selling it as an asset sale or selling it as a stock sale, because there's different tax consequences that both parties negotiate as part of a allocation schedule for tax purposes. So when you're thinking about what is the best structure to sell your medical practice, it's important to be able to consult with a CPA or a financial planner who understands what is involved with the sale of a medical practice. Now, in terms of getting your practice ready for sale, there are a lot of different documents that we tell our clients to essentially make sure are up to date, current, before the process begins, before you start actually having a conversation with a broker, having a conversation with a potential buyer. So the key documents that we recommend would include financial, because you want to make sure profit and loss statements, balance sheets, tax returns, they actually provide a clear picture of what the financial health and performance are. So that's important for purposes of getting the fair market valuation that you would need as well for the sale of the practice. In addition, patient and operational records should be up to date, as well as maintaining patient privacy and confidentiality. So we'll discuss what that entails with a proper NDA. So an NDA is a document that ensures the confidentiality of any documents that are provided to a buyer during the due diligence process. Another set of documents that I encourage clients that they should have up to date is to review their employee handbooks, to review their policies and procedures, to review the employee files, to audit them, to ensure that everything is up to date, because a buyer is going to be essentially either taking over those employees, and the seller needs to make certain representations as to whether or not the employer is complying with various laws, including employment laws. And if all the policies are not up to date as part of the due diligence process, the seller could lose a viable buyer just because all the policies are not up to date. So in the representations and warranties, there may be an issue with not providing an accurate representation, which could then create a situation where a buyer could argue that there was a breach, even though these documents would be produced during the due diligence process. And it could result in a buyer deciding not to pursue this transaction. And so before the seller, medical practice, even decides to sell, a lot of times what we've done is we'll look at all of these documents. Of course, the financial documents, we will refer to their CPA, but in terms of policies and procedures, we will update them. And if it's a sale, a stock sale, we'll make sure that all of the corporate records are also reflecting and up to date with corporate minutes. So all of those documents need to be up to date to get the best value purchase price and to provide accurate disclosures to the buyer. In terms of additional documents, there would be vendor contracts, potentially managed care contracts. Want to make sure all of that is compiled for the buyer, because that is something that they would absolutely want to see in terms of what they are actually looking to purchase in the purchase of the medical practice. Of course, regulatory compliance, having an internal audit to ensure that the practice is compliant with healthcare regulations as well. All right,
Yeah,
so
so
go ahead.
okay. Yeah, so an ideal timeline for the sale of a medical practice, on average, it's 3 to 4 months. Sometimes it could take up to 6 months, depending on what documents are exchanged and like the review process. But there's 8 like primary steps. Conducting a search is just when you're finding a buyer or seller. A lot of the times our clients like find each other at networking events, or it's a colleague they've like known for years, so that could be pretty quick. And then the NDA is just a document that you sign before the sale that protects confidentiality. And then soft due diligence is just basic research before going into the letter of intent, which outlines the basics of the sale. And then we'll go through more of these in the next slides, but basically each additional steps takes 2 to 3 weeks up until closing. But the primary five for steps 5 to 8, the primary sort of steps is just to sort of compose the documents and make sure it reflects the intent of the parties, and then double check all the representations within those documents.
Yeah, and I can tell you that we have some deals where clients say, I need to sell my practice in 2 months. That's just, that's what we need. So of course we will expedite it. We will work with either if we represent the buyer or the seller with the other side. But generally speaking, in order to have a proper time frame, this can take longer depending upon the closing conditions, depending upon the amount of time for due diligence, whether or not there was any due diligence prior to preparing the deal documents or not. So the document that we just discussed, which is really the first document in this type of situation, either buying or selling a medical practice, is the non-disclosure agreement. And it's important to have a healthcare attorney involved in the preparation of the NDA when selling a medical practice, because a lot of times what I see is that NDAs do not include any handling of sensitive patient information with language that involves HIPAA regulations or requirements to protect sensitive patient information and healthcare information. So that's something that is the first step, is to making sure that you have a proper NDA in place and it is signed by both sides. And if the transaction does not go forward, I always put in my NDAs that all documents must be destroyed within a certain time period. And of course, the confidentiality related to what was shared should be indefinite, because it may include, certain information that is, protected by HIPAA, or it could include confidential trade secrets as the due diligence process is moving forward, and it could include employee privacy information, and all of that should have an unlimited time frame of how long the confidentiality has to be invoked, essentially. So this is a very, very critical document. I can't tell you how many times physicians have come up to me and they won't have an NDA. They'll already have been sharing, all kinds of information about their practice, about their patients, about their employees. I mean, it's just, so we always tell them we need an NDA in place, and we need it to be basically retroactive to when you started giving this information. So that is definitely a very important first step that we recommend, and it should be done right.
And then conducting due diligence on the buyer side basically means, as a buyer, you're confirming all material facts regarding the sale. And the way you do that is, for every like representation or statement in the purchase agreement, you see what documents support that assertion. So you would go through the financial statements, contracts, operational procedures, and overall compliance with laws and regulations. And then for medical practice that's owned by one individual or a few, the due diligence process on the buyer side is ongoing throughout the whole process. Um, and right here we have a sample due diligence form to give you sort of like a checklist of what to go through, but the main important items we've highlighted on the left. So it's any leases, regardless of if there's one or multiple, taxation information for federal and state, and any audit letters from the IRS, and then employee information is always really important. And that's all encompassing. So it's employment, like files and contracts, any like disciplinary records, as well as anything related to like litigation or a governmental investigation. Like, for example, if somebody makes like a labor complaint with OSHA, you'd want to know that before you buy the practice. And then assets to be sold basically just states what specific items you're buying and the condition that they're in. So for like a specific medical device, you may want to include that. And if it's not in good working condition, that would be something you would want to discuss before you sign the agreement. You may want to buy it like as it is, or you may like deduct the purchase price down a little bit in order to have money to repair it. Um, and then last is corporate governance documents. This would be anything filed with like the Secretary of State. So like uh, bylaws, articles of corporations, and things like that.
Yeah, and this is just really a partial list because, of course, you want to take a look at all the managed care agreements, the payer contracts, all the insurances that basically any hospital privileges, and all documents related to running the medical practice. So there will be an initial list of documents, you'll review the documents, and then more information would generally be requested based on what's being provided and what's not being provided. So, of course, you want to work through counsel to help review some of these documents to ensure that, a lot of just to ensure that these are up to date, there are no issues that the buyer is, taking on. And if there are, can we have carve outs in the agreement, a holdback of the purchase price to ensure that any potential litigation that could include the buyer would be covered through a percentage of the purchase price that wouldn't be released for a year. Or alternatively, of course, indemnification provisions, but sometimes that's not sufficient if there are certain pre-litigation or litigation issues that are apparent with the medical practice.
Yeah, and then a letter of intent is a non-binding letter that kind of clarifies the expectations of the parties and formally states that the buyer and seller will enter into a deal by outlining the basic terms of the agreement. So the identification of the parties just gives the contact information or the company information. The description of the transaction is sort of like the format of the transaction. So it could be an asset purchase agreement, a stock purchase agreement, or in like rare cases, a merger or acquisition. The purchase price and payment terms just gives like the rate you're willing to pay, and sort of how you're going to pay it. So sometimes people will do an installment payment over the course of like multiple years. Sometimes buyers will pay half at closing and the rest in accordance with an installment payment. So you just sort of have like the basic outline of those terms. And then due diligence, as we discussed, is the buyer's right to review and investigate the practice assets. And the LOI will state the sort of like the time frame for that. Um, Likewise, confidentiality just sort of like piggybacks off the NDA and ensures that like all information during due diligence stays confidential. The primary benefit of a letter of intent is the no shop clause, which basically is an agreement by the seller not to solicit or obtain offers from other prospective buyers for a specific time. So this is good because like if you're eager to close the deal, it just ensures that um, a buyer won't pull out last minute, or that a seller like may like not find another buyer when you're like actively trying to purchase the business. And the proposed timeline just states, again, what we discussed before, whether it's going to follow like a traditional timeline being about like 3 months, or whether it's expedited and in the sense that we need to close like a lot sooner. And then the conditions to closing are conditions that must be satisfied before the transaction can close. This is typically like funding is the most important. Like if you need a loan, the condition of closing would be that the buyer is actually able to obtain the loan and transfer the money. Or it could be a condition as such as like the seller needs to fix any issues within the business before it can be sold. And then lastly, we have termination, which is conditions under which either party can walk away from the deal. And then as an optional discussion point in the letter of intent is the subject matter of a consulting agreement. When you sell the business, a lot of the times you want sort of a transition in place where the seller stays on to sort of like hand the rope over to like the seller. So they provide like operational support. And the letter of intent kind of gives like the very basics of that. So an example could be a seller will stay on site part-time for 2 to 3 months to aid buyer with day-to-day operations and like patient transition. That's optional, but it's pretty common usually we've seen with buyers and sellers.
Yeah, and then one other condition to closing that we generally see is the assignment of the lease. So the landlord, and sometimes this becomes a big holdup, the buyer has to step into the shoes really of the medical practice of the seller. So the landlord has to approve the transfer of the lease, or if it's not a lease assignment, the buyer needs to actually, be able to get into that space, because otherwise, where will they run the medical practice? So that sometimes is a big holdup, because you're waiting for a third party. Sometimes you're negotiating with their legal counsel. And also one of the things that we do is, we have to read the insurance payer agreements with the insurance companies. And if they're already providers, can they even sell their practice? What type of notice requirements do they need to give? So that the buyer can actually, step into the shoes of the seller. And so, those are also certain conditions at times. And if those conditions cannot be met within certain time periods, there can be something called a transition agreement, where the seller agrees that once the deal closes, that they will allow their NPI number to be used for billing purposes until the seller can actually then step into the shoes and take over all of these contracts with the insurance companies, or alternatively, sometimes even with the lease, if it's taking longer dealing with a landlord. So the asset purchase agreement is probably what we see 90% of the time when we're, working with the seller or the buyer. And the reason that the asset purchase agreement is so frequently used is because of the fact that, you're not taking on the liability of the seller. You're just purchasing the assets of the seller, and you're not taking on the entire liability of the selling entity. So there's a little bit more flexibility here with what assets are being purchased, what assets are being excluded. And it's better from a buyer's perspective, because you're just not stepping into the shoes of everything that the seller has, could or could not have as a potential liability. So in terms of the asset purchase agreement, it's basically what we just saw in the letter of intent, but very much detailed. And so the asset purchase agreement includes, all of the terms of the letter of intent with detailed explanation of what, when the purchase price, how will it be paid, the closing date, the financing. There will be schedules as to what assets are being sold, what's being excluded. There's also a purchase price allocation as to what amount is actually going to be considered ordinary income, capital gains, which is negotiated between the parties after discussion with their CPAs, and that gets reported to the IRS. all representations regarding any disclosures as to any litigation, any issues with employees. Essentially, every single term of the letter of intent is prepared in a very detailed format with disclosures. And there's a closing date that is in the asset purchase agreement. And then one big part of this, which Jack, you can discuss, the reps and warranties.
Yeah, so representations and warranties are both assertion. Representations are statements of fact about past or present conduct, and sort of like business standing, whereas warranties are assurances about a future state of certain facts relating to the contract. So both of these are kind of important because they could provide the basis for a breach of contract claim, depending on the language of the representation of the warranties. So a representation and warranty about organizational structure and authority means that the seller has full power and authority and capacity to sell the business, and that there are no pending or threatened actions that might affect the seller's ability to fulfill its obligations under the agreement. So like one example of that could be like an undisclosed like pending lawsuit that the seller is like involved in that they don't disclose. And the next representation warranty is about ownership and condition of assets. Just means that the seller owns all assets free and clear of any encumbrances, and that the supplies are in good working condition except for normal wear and tear. So this just provides protection in case a medical device or a piece of furniture breaks and it has like an adverse impact. This would provide you the protection for that. Next, we have accuracy of financial statement. So this just ensures that all financial statements have been prepared in accordance with generally accepted accounting principles and that there have been no material adverse change in the financial conditions of practice. This basically just provides the protection that the finances that you're disclosing and the condition is what it actually is, and that there isn't some material change that the buyer wouldn't find out about till after closing. And compliance with laws and regulations just provides a representation and warranty that you're following all applicable like laws and compliance mandates. So for healthcare, it's usually HIPAA and Medicare and Medicaid regulations, but it would also include employment laws as well, and any necessary permits and licenses as well. And then next, for patients and records representations and warranties, this just ensures that patient records are accurate and up to date, and again, in compliant with all applicable healthcare laws, and that there are no pending or threatened claims by patients to the practice that's selling. And then for contracts and agreements, this provides a representation and warranty that the sale of the medical practice won't violate a pre-existing contract that the seller has, and that there are no employment contracts, agreements, or collective bargaining agreements that are currently in effect. And then representations about and warranties about liabilities. It just means that the seller discloses all liabilities, whether current, contingent, or anything else. So the seller is in essence not aware of any undisclosed liabilities that may become responsibility of the buyer. And then taxes and representations and warranties just mandates that your taxes have been paid, and that any required action from the IRS or like applicable state authority has been dealt with before the sale of the practice. And last but not least, representations about employees and benefits is where the seller provides accurate information regarding employees, their compensation, benefits, and that there are no former or current disputes regarding like labor violations or unpaid wages claims.
Okay, so this is very, very, very significant for both the seller and the buyer. And if there are any issues with any of these categories, the seller is required to list what they are in a disclosure schedule. So the asset purchase agreement will state that there are, everything is accurate, everything, all financial, for example, all financial statements have been prepared in accordance with GAAP, or that the practice is in compliance with all applicable laws and regulations. But if there's an issue that they didn't comply, and the buyer finds out afterwards, it could unwind the deal. So let's say there is a dispute with an employee, and the employee has relayed that they're planning on filing a lawsuit related to unpaid meal and uninterrupted meal and rest breaks. That's a very common one for a medical practice. And in fact, this medical practice may have upwards of 100 employees over the course of 3 or 4 years. And the medical practice, because it's so busy, there are not, in terms of the meal breaks and rest breaks, they're not uninterrupted. There are claims by, other employees. This all has to be disclosed in the disclosure schedule, because if there's a class action lawsuit after the practice is sold, the plaintiff's attorney is going to include all, the name of the original practice and the successor practice. The successor practice that purchases the original medical practice, if they find out, they need to be indemnified. So there has to be a disclosure, and they could even unwind the deal. I've actually seen this happen. So it's very critical that, and they can get damages. There's attorney's fees for breach of contract. So this asset purchase agreement, these representations that the seller is making must be accurate, so that the buyer can plan and say, I still want to buy the practice. Let's put a holdback amount for 10% of the purchase price so that it covers that. Or let's have the indemnification provision specifically include certain issues. It generally will include anything prior to closing the seller has to indemnify the buyer for. But if there are very specific issues, like with a patient, if there's a med mal claim, all of that has to be disclosed, because the plaintiff's attorney has to bring in, the successor entity as well. And so you want to make sure, and this is what brings me to my next slide, that these disclosures are accurate for the protection of both parties. Now, indemnification clauses have to be carefully drafted. There is generally, what I see, a general indemnification that says anything pre-closing is the seller's responsibility. Anything post-closing is the buyer's responsibility. And let's say there's a litigation that takes place, the buyer would be responsible for anything post-closing that occurs. But the language needs to be very specific as to what the indemnification procedure is. Okay, and that's what's going to trigger the indemnification. So sometimes I see just a very broad-based, okay, anything pre-closing, anything post-closing. But if there's no specific indemnification procedure, it can become a huge problem. So the indemnification procedure basically states, like, if there is a claim, who do you notify? How soon do they need to be notified? And how can they, how can this be defended, indemnified? Does the buyer get to choose their own attorney? Or does the seller choose an attorney that they want to use if the buyer gets sued for a claim that happens prior to the closing date? And let's say there's a claim that takes place, and years later there's a settlement, and now the buyer is saying, well, this was an employment case and they've spent already $200,000 or $300,000 defending it, and they're now telling the seller about it after the case is over. Well, the seller should have had a chance to handle it with their own attorney, and they could have handled it for 15 grand, so how does this procedure work? How does this indemnification, what are the steps for the notification so that both parties can be protected? There's always a tax indemnification. So the seller agrees to indemnify the buyer for any pre-closing tax liabilities. You always see that. Breach of covenants. So, if there's a breach of a covenant of the term, You'll always see in these agreements that the breaching party is required to indemnify the non-breaching party for any losses resulting from the breach. And if there are any third-party claims, the seller usually agrees to indemnify the buyer against any claims brought by third parties related to the operation of the practice before the sale, including patients, vendors, or other parties. And then post-closing liabilities. So any, specifically any liabilities that only take place for operation patient care after the closing date is usually assumed by the buyer. And breach of representations and warranties. So if there is a breach, there's always a provision in here. So if the seller doesn't give the truth about, certain issues, including the financial condition, compliance with healthcare regulation, the seller always generally agrees to indemnify the buyer if something is false or inaccurate. So these are the types of indemnifications that you would see in this asset purchase agreement. And you would see these in a stock purchase agreement as well.
Yeah, so closing condition and contingencies are a series of requirements that must be fulfilled in order for the deal to close. And if those contingencies are not satisfied by the closing date, it could provide the buyer with the right to terminate the agreement and retain any deposit that they put down. So common examples are financing, which asks like, was the buyer actually able to obtain the money? This could be a private loan from a bank, or like half of a deposit up front and the rest later. But ultimately, it's the purchase price being paid. Assignment of contracts as are there any contracts with third parties that need to be assigned, and that must be assigned before closing? So this is typically leases. With insurance carriers, we sometimes see that they require advance notice of a sale. So they permit a sale, but you have to give them like 1 month's notice sometimes. And then employee retention just asks if the buyer wants to keep any employees of the sellers for a limited amount of time or permanently. And then a material adverse change is a common condition that basically states there have been no material adverse changes in the business between signing and closing. And the completion of due diligence just basically is a contingency that both parties have fact-checked all material like statements in the asset purchase agreement before closing.
All right.
Um, Yeah, and then asset purchase agreements, governing law and dispute resolution provisions are basically they sort of address like what is the protocol if there's like a breach of the agreement and there is a dispute. So typically with governing law, we always choose California. And then dispute resolution, your options are to um, have like state court arbitration or mediation. We always recommend arbitration because it maintains a greater degree of privacy, and oftentimes it's cheaper and quicker. And then many times we also require mediation before arbitration. So mediation is sort of like it's a mutual agreement between the parties in a dispute resolution setting. And then if an agreement can't be worked out in that, there would be a mandatory arbitration clause.
All right, so stock purchase agreements. So as I mentioned earlier, we generally see asset purchases, but there are also a lot of practices where, a handful of practices where if it involves family members, I'm generally preparing a stock purchase agreement between the family members who are physicians. And at times, because it does take a while to step into the shoes of the provider in managed care contracts, there are some situations where the buyer prefers to have a stock purchase agreement. I would say, we only see this about 10% of the time for stock purchase agreements, and that's because essentially, when somebody is purchasing stock, you're taking over the entire entity, and it's really almost impossible to separate out liability when you're taking over, a medical practice, just the ownership of a medical practice that's already had a tax ID number, has been in practice for a number of years. You're generally taking over all the liability, no matter how much you try to carve out the indemnification provision. It's almost impossible. So if you're coming in and you're taking over somebody's medical practice through a stock purchase agreement, you want to make sure those indemnification clauses are bulletproof. And how will an individual indemnify another individual? There's so many different there's insurance indemnifications through insurance, but in terms of liability in general, it's always recommended, at least when I'm representing a buyer, that there should be a very clear indemnification clause with specific triggers. So mergers are actually even less common than stock purchase agreements or asset purchase agreements. So with a merger, essentially what's happening here is two or more entities combine to form a single new entity. And essentially there's something called a merger agreement, which includes conditions of the merger, distribution of ownership, structure of the new entity, and many times after a merger agreement is entered into, a new entity is formed. And so essentially, you can have multiple corporate entities potentially merging into one corporate entity, and that allows different practices to share resources, enhance their capabilities. And so when the new entity is typically formed, the terms of the liabilities are more easily negotiated. Whereas if you are purchasing, you're basically becoming 100% owner, taking over through a stock purchase agreement, purchasing an entity through a stock purchase agreement, you're essentially just assuming the liability. So this gives you a little bit more flexibility with a merger as to who is responsible for what, because you're creating a whole new entity. And so, but you're bringing in both practices and so forth. But they're very complex, and there are a lot of different tax issues and ramifications as well to consider. So we do see these a lot less likely, and we would, in these situations, we work very closely with financial advisors and accountants. And then for the merger agreement, we see pretty much the same type of structure that we see with the asset purchase agreement. So, we have got the parties, the purpose and objectives. What are the assets? What are the liabilities that are being brought in to this new entity? What are the financial considerations? Who is governing it? Is it a corporate? Of course, if it's a medical practice, there are certain regulations that, you cannot have an LLC, for example. So if you're practicing medicine, you can't be an LLC. You have to be a corporation. So then, who owns what number of shares? And so for medical practices that are merging, who's involved, in management? Who's the president? Who's the secretary? Who's the treasurer? What do the shares look like? Which employees are being brought over from the different practices? And then you'll also have language related to regulatory and legal compliance issues, representations and warranties about both practices, of course, confidentiality and dispute resolution. Now, handling of patient records. This is something that is very important when selling or purchasing a medical practice. So in terms of the sale of a medical practice, a lot of folks think, oh, I'm selling my patients. That is unlawful. If you have a purchase agreement that is not drafted by a healthcare attorney and your asset purchase agreement in the schedule of assets includes patients, that is unlawful under California law. You cannot have that in California. The only thing that you can have is language that says that the patients and their medical records are being transferred as a custodian of records. A physician cannot own a patient's medical records. So essentially, they have to be transferred through something within the purchase agreement that says the custodian of records transfer to the buyer. And in fact, there are a lot of regulations involving patient abandonment issues. So there has to be joint notification provided, as it pertains to providing notice to patients when a seller is selling a medical practice. Now, when there's a transition, the seller should be involved because of patient abandonment issues. It's very critical that there be some transition process in addition to the notification, so that the seller cannot force the patient to then have the new buyer physician as their physician, but the seller can make an introduction and say, I'm selling my practice to this, very well-known physician who's specialized. So even if you're choosing to sell your practice, you want to make sure that if you're selling your practice, the medical group that you're selling it to is experienced enough, is specialized in your area enough, so that the patients are going to be in good hands. When you actually let the patients know and notify them that the practice is essentially that, the selling physician is selling the practice, and that they have a right to, to go to another physician, or they can work with the new physician who they are selling the practice to. So there should be some transition assistance. I mean, this is pretty much standard. Physician can't just say, oh, I'm selling my medical practice and then take off. I'm retired, they can't do that. So, and that's because of this whole patient abandonment issue. Plus, transition assistance is usually required. There's usually a delay between getting the buyer's NPI, number basically connected with the billing and with the new with the insurance agreements. There's a procedure involved in a lot of these contracts where we have to notify the insurance companies, or the, for the provider agreements, the provider groups, the managed care groups. And so maintaining those relationships, transitioning the practice, it's part of what the buyer is buying. So the buyer would need or want the seller to be involved to ensure that transition it takes place. And I have been involved in many disputes where the seller just doesn't assist or doesn't provide enough assistance, and then the buyer is basically left saying, well, what did I purchase? So it's important to have a very clear consulting agreement, or keep the selling physician on for a year or two, so the transition is easier for the buyer and in general for the patients and the practice. So there's also the selling physician who, as part of the purchase price, you don't have to just pay, you can break it down. What the fair market value purchase price could be with an employment agreement that is basically for a term. So I've seen that happen as well. So let's say the valuation comes in at like 1.5 million. I've seen deals take place where at the closing date, $1 million is paid, and there's a guaranteed salary for the seller physician to stay on, for a guaranteed salary of at least 500,000 or something along those lines. So that covers the valuation issue structure. I've seen that happen through different transactions as well. And so if the selling physician stays on as an employee, the terms that you would see include compensation, benefits, termination, restrictive covenants, non-solicitation, non-disparagement, non-interference, things of that nature. So that basically the buyer is able to protect the medical practice that the buyer has purchased. And then in terms of, sorry, let's go here. Non-competes is always a very significant part of the sale of a medical practice under Business and Professions Code 16600. The seller can be restricted from competing within a certain radius or a certain time period. And this is the only way under California law that anyone can be restricted from competing, is if you're selling a business, you're selling your shares, or you're selling the assets of a business. And so non-competes for a buyer are very valuable. And in the allocation of the purchase price, that is a very significant component of the purchase price. So you want to make sure that sometimes we actually have the completely separate, depending upon the value of the non-compete, we have that as a separate agreement. So we reference it in the LOI, but we have a full-blown agreement if there's a breach of it, in addition to the asset purchase agreement or stock purchase agreement. It's not generally, I mean, sometimes it can be a term. It just depends on how important this is for the buyer and what impact that has on the purchase price. So generally, it has to be a reasonable scope as well. But, there are some exceptions. So that could include like nonprofit work, volunteer work, teaching, consulting. That doesn't include, poaching of the patients or anything like that. And then finally, transition of the medical practice. It is a complex process. So it's important that there's a communication strategy, with the patients, the staff. A letter needs to go out to the patients related to the sale. And so pursuant to state and federal regulations, patients must be given the option to choose another healthcare provider or have a copy of their medical records sent to the physician of their choice, should they not want to work with the buyer physician. So medical records and other personal information cannot be sold to somebody. The patient has a right to choose. So that's why it makes selling of a medical practice, buying of a medical practice, a little bit unique, in the sense that there needs to be a transition plan in place. And if you don't have that in your agreement, the buyer could be in a situation where, what has been purchased essentially for a medical practice. So you definitely need a clear agreement here that specifies how much time the seller has to provide as a physician to the buyer to help with the transition. And that is quite significant. And then operational integration. So we have language that allows, accounts receivables of the seller. They need access to the EMR records up to 6 months so they can, get their billing. They can get their accounts receivables, because accounts receivables are an excluded asset of the seller prior to the closing date. So, how much access they should have access to receive the receivables from their billing done prior to the close of the sale. And then retention of key staff. So those are issues that require a transition plan as well. Continuity of care, and then of course, at times there could be some rebranding that would, that the buyer may have as well. So I think that's it for us. So if anybody has any questions, let us know.
That was phenomenal, you guys. Thank you so much. Wow, that was very comprehensive. And I think there are a lot of legal landmines that physicians and practices have to really look out for if they're going to engage in this. So they would really be wise to contact you all because you're experts in this. So let's see, let's take a look here. There are a couple of questions. And Maria, I'll just read them out loud. I know you guys can see them, but I'll read them out loud so everybody can also hear what they are. How does a right of first refusal, ROFR clause in an HMO IPA contract affect the process of selling a medical practice? Is this type of clause standard in IPA agreements, or is it something that can be negotiated or removed? How does it affect market valuation?
Okay, yes. And I've dealt with this a lot. Actually, Jack and I have worked on a couple of deals. Just he's even had experience on this. So, a lot of the providers want to see if they can match what the fair market value asset purchase a letter of intent is. So generally the way it works is that, and it is very common. So it's extremely common because like the huge conglomerates, without naming any names, you all know who they are. They want to take over all the medical practices, and specifically in certain areas. So what has to be done is the provider physician needs to find a buyer and get a letter of intent prepared and sent over to the group that has the right of first refusal, and give them an opportunity to see if they can actually provide an offer that's better. And sometimes even if it is better, there's so many different factors to look at, so it is negotiable. And I have gotten physicians out of those right of first refusals so that they can sell it to a physician group or a physician that they feel comfortable with. But you need to actually have a letter of intent, prepared between the potential buyer, and then that needs to be sent to the group that has the right of first refusal. And then you can start negotiating. And if they don't give you an offer within a certain period of time, then you can proceed forward. But you want to make sure you review that agreement carefully, and you ensure that timing, they have enough time to respond. And if they don't, you can just say, look, you didn't respond on time and you didn't give me a counter. And a lot of times if you want to sell to a different entity or physician, it is pretty much, you can negotiate. But I've had certain situations where my clients were hamstrung and they're like, well, they're offering so much more money. And then, but there's other caveats with it. You have to stay on as an employee for 2 years or 5, and they don't want to, they just want to retire. So a lot of different factors. We can help you get out of those potentially, but there's a process involved.
Great. Maria, did that help? If you yeah.
And I think I even know who you're right of first. Like, it's just there's a couple of groups that are doing this. So I mean, the Optums and the Regals, and yeah.
I was gonna say we probably we know exactly.
We negotiate with them all the time for our clients.
Oh wow. Okay, very, very useful. Great. Justin has a question. In the sale with closing conditions, as far as retention of patient records, such as charts, either electronic or paper, whose responsibility is that, seller or buyer?
So if it depends. So, you're transferring custodian of records to the buyer, right? So you're transferring it when you sell it. So it depends on have you transferred it or not? Then it becomes the buyer's responsibility. So but the physician has an obligation to have access to those records and as well. So depending upon, you know, have you already transferred it, but you still need access to those records as well for a certain period of time.
Great. All right, Gregory has a question too regarding shareholder transfer, for example, buyout. Is patient notification required or necessary?
So if it's the same entity and it's a different physician, I would still recommend notifying the patient, because even if it's the same entity, you have a different physician who's going to be, you know, taking over. So I would recommend notification. I always err on the side of caution.
That makes sense. Okay. Let's see. Gregory, same MD. What if it's the same doctor? Same thing though, just be
Then
careful.
you don't need to. Yeah, you don't need to.
Oh, then you don't need to.
Yeah, like if you've already been working with that same group, it doesn't make a difference. And yeah.
Okay. You're welcome, Gregory. Well, that's all the questions in the chat. We do have somebody just wanting to make sure that you're comfortable with us sending out your slides. Is that okay?
Yeah, the PDF. Yeah, you
Yeah.
can send the PDF. Not a problem. More than happy to share.
Okay, that's wonderful. So Chris Ostomo, we'll definitely, and everyone will definitely be sending this out along with the recording of this presentation. Does anyone else have a question you'd like to ask before we break today? If you do, feel free to speak up. Okay. Well, I guess that is it. That was very comprehensive. Again, you guys, thank you so much on behalf of San Bernardino County Medical Society and Riverside County Medical Society. We're getting lots of comments in the chat saying thank you so much for a great presentation. And thank you for being such a wonderful business partner to both medical societies. You've really been a trusted professional partner to so many of our physicians in our practices. I mean, you guys have just really helped so many of them and us navigate our way through these issues. Okay, well, we'll see you all next time. And Pamela and Jack Ryan, we'll look forward to our next webinar with you guys. And thank you so very much for your time. And thank you everyone for joining today. And we hope you have a lovely rest of your week.
Thanks so much, everyone. We appreciate it.
Thank you. Bye-bye.
Have a good day.
Thank you. You too. Bye-bye.